I will count on Ahmed and Connor to let folks in as they enter. Welcome to Taking a Faithful Stand. This is our commitment as faithful people to civic engagement, learning about our communities and how we might make them good places through our connection. I am Reverend Carrie Parker, the Executive Director of the Wisconsin Council of Churches, one of the co-sponsors of this series, which we have been running for the past several years now, along with the Interfaith Conference of Greater Milwaukee, our friends at Wisdom, and Wisconsin Faith Voices for Justice. And I am delighted to have many familiar faces here, as well as a few new folks who are registered. We are recording tonight, so if you've missed something, if you have to step away for a second, you can catch up to us on the recording, which will be posted just a few days after the event, and that link will come through your email. I'd like to start us off with a brief prayer reflection. So find the spirited place in your heart and join me in a spirit of prayer. Holiness, in all the ways we know you, in all the ways you inspire us and give us courage and thoughtfulness and connectedness. Bring us to the purpose of this evening. Help us to be where we are and be for our communities. Let this be a meaningful time to equip us to use our best gifts for those you love, for those we love, and for those we are coming to love. Amen. Ahmed, would you introduce our speaker this evening?
Yes, thank you, Carrie. So I'm pleased to introduce James Santelle this evening. For approximately 30 years, Jim served in the United States Department of Justice, most of those as a criminal prosecutor of various financial fraud, public corruption, commercial theft, and violent crime enterprises, and also as a civil litigator of a variety of government programs. And for 6.5 of those years, he served as the United States Attorney for the Eastern District of Wisconsin. Jim's tenure as a United States Attorney was specially punctuated by two events that changed our world and our nation. The first of those was in the wake of the attack of September 11, when he engaged directly and intimately with local Muslim populations to ensure that their civil and human rights as members of our American population were and remained protected. And then also following the hate crime attack against the Sikh community in Oak Creek on August 5th, 2012. Jim similarly reached out to the populations of the Sikh community in Milwaukee and the greater area, not only in an investigatory capacity, but also to provide information about the violence that took the lives of the Sikh worshipers on that terrible day. Jim is a long-time resident of our area. He was a 1980 graduate of the College of Arts and Sciences at Marquette University in English and History, where I always have to mention where Jim and I took a couple of classes together, and also a 1983 graduate of the University of Chicago Law School. After that, before joining the Department of Justice, he served for 2 years as a judicial law clerk to United States District Judge Robert Warren. Since completing his service with the Justice Department, Jim continues his active legal practice in state and federal courts in Wisconsin. Jim, if you could take it away.
Ahmed and Carrie and Connor, first of all, let me thank you so very much for this opportunity to be with you again this evening. It is both a professional honor and a personal delight to do this once again and to be engaged with your membership in discussion. And yes, indeed, as Carrie indicated, with all good intent and purpose, we'll leave some time for questions at the end. We are gathered this evening remotely to talk about the United States Supreme Court. You see a picture there of the court. It right now is under a bit of construction, which perhaps is a literal representation of some of the goings on there at the court these days. But we're going to spend some time talking tonight about some of the major cases of the United States Supreme Court in the last term. And we're still in that term right now. The next term begins in 3 short weeks. And in that connection, also at the outset, want to thank all of the sponsors listed there tonight for inviting me to come into your presence. Let's begin with some basic information about what we're going to be talking about tonight. It's going to be relatively quick as well because there is so much material and do want to give you some opportunity to ask questions at the end. We're going to do a little bit of statistics on what the Supreme Court docket looked like in this past term. I am going to be spending, and maybe not an inordinate period of time, but a lot of time on really 2, maybe 3 major cases that I think are the landmark cases of this term. I'm going to be spending much less time talking about 8, 10, 12 other cases. Each one of them could be the subject of an hour-long presentation. I'm going to mention them to you and just indicate to you how significant they are. Then we're going to spend some time necessarily talking about something that I know you all know well, which is this emergency docket. We saw it again just yesterday, and we'll talk about that case, sometimes called the shadow docket as well. And then this is the perspective of Jim Santelle, modest and humble though it is, just some overall senses of what we can take away from this term of the United States Supreme Court. Again, an ambitious but achievable agenda. There they are. And I suspect everyone gathered here together can name all of them. This is not a quiz, but I suspect one of the things that each one of you can do is identify each one of them. I'll do it very quickly. The Chief Justice right there in the middle, his name is John Roberts. And by areas of seniority here to his right, to our left, that's Clarence Thomas. And beyond Clarence Thomas, that's Sonia Sotomayor. Rounding out the front row there is Sam Alito and Elena Kagan. In the back row, you've got the sophomores and the freshmen, so to speak. That's Amy Coney Barrett and Neil Gorsuch and Brett Kavanaugh and Ketanji Brown Jackson. You're going to hear from virtually all of them tonight, not directly, but through my words and through some of my interpretations of what they've been up to for this past year. It's also important to recollect, as we always do, that we live in a nation that is both a federal system and it's a republic as well, obviously representation. But as part of federalism, we have states and we also have a federal government. And that's the beauty and perhaps some of the mystery of our Constitution. That map shows you, and I know you've seen this before, all of the major circuit courts in the United States. We're in the 7th Circuit right there, that lime green area right in the middle. But we're going to hear tonight from, for example, the 9th Circuit, the 4th Circuit, the 5th Circuit, and also some district courts on the eastern part of our nation, including in New Hampshire and Maryland. And again, way out in California, the Central District of California, some district court judges as well. We spend most of our time talking about the Supreme Court, located, of course, in Washington, D.C. But necessarily, we know that the cases of the Supreme Court come from lower courts. They come from the district courts. They come from the appellate courts. And yes, indeed, as you know as well, they can also come from the superior courts of the various states, including right here in the state of Wisconsin, other places around the nation. And again, recognizing that we do have this system that produces cases from across the country. Let me give you some of the statistics. There are some pictures, if you will, of the United States Supreme Court way back in 1934, 1935, when it was under construction. I suspect that all of you have been there, right there on First Street, not too far from the Capitol. In 1935 construction, again, it has recently been undergoing some tuck pointing, and maybe then an appropriate circumstance to talk about some of the statistics here. The Supreme Court in this past term issued a whopping 65 decisions. That's pretty much on average with what they have done recently. They've had oral arguments, which are the opportunities for the lawyers and the parties to stand in front of them in that building and argue their cases, to get questioned by the justices and to argue their cases on behalf of their clients. You can hear those oral arguments both live and recorded by going on the Supreme Court website. They began way back in October of last year and they continued until April 30th. The rulings themselves on those 65 cases, and yes, indeed, many others in the emergency docket, those were issued beginning as soon as November of last year, right after the Supreme Court's term began, and they continued through the end of June, right before the 4th of July holiday. Only 2 of the cases this term were from the Seventh Circuit. And we're not going to be talking about those tonight just because they did end up on the cutting room floor. Note that the Fifth Circuit, which again, the South basically, generated most cases, which is somewhat unusual given the usual practice of having a lot of cases from the Ninth Circuit. But the Fourth Circuit was in there as well. Again, sort of the Middle Atlantic states there too. State Supreme Courts produced 6 cases this past term. So let's begin and talk about two of the major cases. These have been in the headlines. You know a lot about this, and I do not need to give you the predicates for this, but there has been a commotion, as you know, about something we thought was pretty much settled. There you see the 14th Amendment to the Constitution. We have spent most of our lives and most of our livelihoods talking about things like privileges and immunities and no deprivations without life, liberty, and due process, and those kinds of things, equal protection. That's where all these concepts come from, in part, the 14th Amendment. There are also some Fifth Amendment aspects to that as well. But you know well that in January, our current president, his name is Donald Trump, issued an executive order. And he took that language from the very first portion of the 14th Amendment that talked about being within the jurisdiction of the United States of America and said that while in the past, anybody who was born physically, geographically here in the United States of America, you're a citizen, voila, just by magic. And that's the way it's been interpreted by the Supreme Court, including way back in 1873. And you see the case there in which the court resolved a case involving a Chinese baby born in California to Chinese parents of Chinese citizenship. And they determined that no, that child born here in California in the United States is a citizen. Our president has contested that notion, and he has said this, that if in fact your parents are either here illegally, especially your mother, or they're here just temporarily, they are therefore not in the jurisdiction of the nation. And for that reason, even though you're geographically born here, you are not a citizen. And that's what he said way back in the first day in office. So what happens is that you get some courts out there. We've got New Hampshire. We'll see a judge from New Hampshire in just a moment or so. We've got the Ninth Circuit way out there on the west side of the nation. And they come along and they say, okay, we're going to resolve challenges to what the president has put forth. And we're going to decide that, yes, indeed, the Supreme Court was right way back in the 19th century. And that if you're born here, whoever you are, under any circumstance, you are indeed a citizen. What happened is that the president of the United States of America said, no, that's not right. I want an expedited review before the United States Supreme Court, and he got it. Significantly, given what we're going to talk about in just a moment or so, this is not one of the emergency docket, one of the shadow docket cases. Although it was expedited, it was the subject of oral argument, was the subject of pleadings, and a lot of review. And during the course of what everybody thought was going to be this resolution, or at least this discussion by those justices about whether or not the 14th Amendment means what it says and says what it means, in fact, they specifically said, we're not going to talk about that. We're not going to decide that issue. And instead, they decided that we're going to talk about whether or not a singular judge, federal judge, or even a singular appeals court can enter an order and make it applicable to all those different jurisdictions, all those different districts across the country? Or is that judge or is that panel of judges restricted just to the area of their jurisdiction? That was a big question. So the Supreme Court took up this issue about whether or not judges in all those different 93 districts, 12, 13 different circuit courts across the country, can they issue an order that is applicable on this issue, yes, 14th Amendment applicability, but generally that would apply to everybody across the board. And it appeared that during the course of the oral argument this past spring that Amy Coney Barrett was saying, well, maybe there's some things that can be subject to nationwide injunctions and nationwide orders. And maybe there's some other things that are regional in nature where we don't have to do that. It was a surprise, therefore, that again, in this case called Trump versus Casa, that writing for the 6-3 majority, Amy Coney Barrett writing as her pen, she said, no, we cannot have national injunctions. If a judge enters an order enjoining, stopping something from happening, interpreting the 14th Amendment or something else in a certain way, that applies either just to the parties in front of that judge, or maybe just to those people in that particular district or that particular appellate jurisdiction. She said there's no basis for having national jurisdiction. Congress didn't do it. And these orders that are being entered by these judges, including on the 14th Amendment, are simply providing relief that it's not available. The court, knowing that it's changing the ways that we have worked here for a long period of time, said, you know what, we'll suspend this for 30 days. That's long since passed. So you can figure out what you want to do with respect to the 14th Amendment. And all of you who thought you might be okay under the 14th Amendment, you can determine whether or not you want to pursue some things. Along the way, the Supreme Court at Amy Coney Barrett's pen said there are some other remedies, not national jurisdiction, not national injunctions, but you might be able to identify a class of people before you that have common interests and common purposes and common facts. And maybe you can enter an order that is of a class nature. And I know what you're already thinking. You're thinking, gee, Jim, is there a difference between those two things? And the reality is, when you pull it all back, there probably is not. But that's one of the remedies that the Supreme Court pulled out. While it decided, once again, as you see there, not to decide the issue of 14th Amendment applicability. They expressly said, we're not making a decision on that. And what happens is, of course, in addition to the majority of 6, including Amy Coney Barrett, you get the other 3. We're going to hear a lot from them tonight: Elena Kagan, Ketanji Brown Jackson, and Sonia Sotomayor, who said, this is just plain wrong. That courts have got to be able, on these big issues like things such as citizenships, have got to be able to decide cases that would be applicable across the board. They acknowledge that maybe there's some regional things that are not fall in that category, but you should know that not only is the executive order, as Sonia Sotomayor said, making a mockery, she said, the president did, of the Constitution, but you've got to have the fluidity and the capacity of judges to enter nationwide jurisdictions, nationwide injunctions under their jurisdictional grant by their oath of office. And so you've got this 6-3 majority that says just the opposite. And that remains the rule of law to this day. What happens, of course, in the wake of that is you get these very strong statements of objection by people like Ketanji Brown Jackson, Sonia Sotomayor, Elena Kagan. You can see there what she says. You know, federal courts have got to be able to tell the president across the board if he, in fact, she, in fact, one day is wrong. And if we don't have that capacity, if district courts and appellate courts don't have that capacity, you're basically giving up something that's fundamental. She says it's the duty of the courts to be last and not first, to give up these basic guarantees in our Constitution. And again, the argument about this goes on, even though, as of the Casa case, right before the 4th of July, no more national injunctions. However, what happens in the wake of that, of course, 14th Amendment issue not yet resolved, we've got district court judges around the country who say, okay, we think the president is still wrong on this interpretation. And there they are. The first one is Joseph LaPlante. He's from New Hampshire. He's on the East Coast. And he says, you know what? I'm going to identify a class of people. They're all the newborns. The president's executive order went into effect in February. All the newborns, I'm identifying them as a class. And I'm going to say that each and every one of them, regardless of whether their mother or father was here legally or not, all of them are citizens. You've got the same thing from Deborah Boardman and from Leo Soroka and other places around the country, basically saying that, embracing class actions and making the decision that the Supreme Court did not, that the 14th Amendment does in fact still grant you citizenship by virtue of the fact that you were born here. The mechanism for getting there may be different. That remains contested. And you should know, of course, that because of these decisions, the president has sought review of the Supreme Court, by the Supreme Court, of these various decisions, including the Ninth Circuit. And so it's entirely possible, we'll talk about what the Supreme Court is going to be doing next term, that in the next term, they may take up the decision that the Supreme Court in this past term did not take up. And that is whether or not the 14th Amendment means something for citizenship. Is the president right? Or are all the other courts right? And is history right when it comes to precedent? It is an unresolved issue. And we do have now a procedural, not oddity, but a change in the way that courts can act because of this refusal of the court to acknowledge national injunctions, other mechanisms still out there. That's a big case. That is a very important case in terms of the jurisprudence of the United States of America. Here's another one that I want to highlight. Again, I could have chosen from 65 of them, but this is another one, completely different circumstance. This comes from Maryland, Baltimore, the biggest district, biggest school district in Maryland. Maryland says that we're going to teach a curriculum that includes LGBTQIA issues. Not predominantly. We're going to introduce this, frankly, at the high school level, at the middle school level, and yes, indeed, at the grade school level. And we're going to include, for example, for the first graders and the second graders and third graders, storybooks on families and others who have same-sex partners. And you see the names of some of those, Pride Puppy and Born Ready, and Uncle Bobby's Wedding, which is one that gets a lot of attention in what happens here. There are parents who come forward and say that on religious grounds under the First Amendment, protected there, you see the text, I have a right to exercise my religious beliefs, free exercise in such a way that I want to prevent my son or daughter who's going to, again, this is public school, very important to emphasize that. This is not applicable to private schools that can indeed do these kinds of things and make those kinds of determinations. Public schools, it's because of the government aspect of the First Amendment. The free exercise clause tells me as a parent, these parents say, that I've got a religious liberty, and for that reason, my religion tells me that my young students, my young boys and girls going to grade school should not be exposed to the messages in these books about LGBTQ inclusive situations and families. And you see some of the language there in the complaint, and not to right away begin to address some of the merits of this, but the allegations in the complaint, frankly, are somewhat extreme, especially if as they say, you're encouraging young people, first and second grade, to focus excessively on romantic infatuation. Even so, that kind of allegation prompts litigation. The school eventually says, we're going to put in place basically an opt-out system where if you want your son or daughter to be removed from class while we're talking about Born Ready or Uncle Bobby's Wedding, we will honor that and will remove that child for that period of time. There's a long history here. The Supreme Court recites it. It becomes untenable as parents are asking that my son or daughter be removed as to this piece of the curriculum, not this one. And because of the administrative aspects of this, the school district in Baltimore shuts the entire process down and says, no more opting out. Can't do that at all. And the parents sue. And they say, and again, under the First Amendment, I've got a right to, under a religious liberty, to have my child not be exposed to these kinds of things. Gets up to the Supreme Court. And the Supreme Court, at the pen of Sam Alito, says very notably in this case that indeed parents are entitled to this opt-out procedure. It is a religious liberty. And although he recognizes that it opens up the door to many, many other things that also could be subject to an opt-out procedure here, he basically says that the religious aspects of the First Amendment compel public schools to grant these requests of parents to remove their students, their young people, from the classes. And he describes in great detail the various storybooks and explains, again, in ways that I'm not going to go into because of time tonight, the ways in which, from his perspective, these books basically indoctrinate and send messages about the LGBTQ families that others may disagree with. And indeed, you see there that by a 6-3 majority, the same as in the Casa case, he describes there a basically very fundamental notion about sexuality, and notes that the storybooks can be hurtful and hateful. That's his language in describing what is going on in Maryland, absent this opt-out procedure. Once again, you get some very, very strong opposition to this. It's the same 6-3 situation. That's Sonia Sotomayor. And she says, basically, you are completely misreading what's going on in Maryland. The teachers are providing a very balanced way of approaching this. And even some of the storybooks, she says, are not promoting anything with respect to sexuality or human sexuality, not promoting an orientation or that at all, but simply exposing young people and older people to all kinds of families. And she also says this, and this is the big takeaway for academics, of course, what you're doing now, while this is interesting as to LGBT issues, but what you're really doing here is you're giving parents a veto over all kinds of things, well beyond sexual orientation and gender identity issues. What about issues related to evolution? She uses an example of what if there's a religion that has a very restrictive view about women's role in the family and outside of the home. She describes that. If in fact that is being taught in some way, direct or indirect, in the public schools, can parents remove their children, opt out as to those? And there are many people who criticize this opinion on that grounds beyond just the LGBT issue. But again, significant as we begin school right now, that school districts around the country, including right here in Wisconsin, across the United States, have got to be aware of this, that not just as to LGBT issues, but the Supreme Court has said that on religious grounds, the First Amendment does give Americans and American parents the right to remove their children on an opt-out procedure if in fact they object to or some other objection to the nature of the instruction being given in public schools. It is a significant case, undeniably, once again. I'm going to identify one other case from among many, many others here because it also underscores something else that's going on. And you'll see more of this at the very end of our time here together. And that is this really a breaking apart, if you will, of even any close consensus among the 6 and the 3. This happens to be a case involving something called standing, and whether or not in California, some regulations, some Clean Air Act regulations that require cars to be forward-looking and basically reducing fuel and emitting pollutants into the air, whether those regulations can stand under federal law. And the question, addressed again by a majority, this time 7-2, is whether or not, once again, the gasoline industry should get the benefit of the doubt here. And the reason I raise this issue here is that because it also underscores what have become some very, very virulent dissents and some very virulent opinions from the majority as well. Justice Ketanji Brown Jackson says here in this case that she is worried about the reputation of the court being a business court as opposed to one that interprets the law. She has most recently, as many of you know, also been sparring with Amy Coney Barrett a lot. And you saw some of that recently in connection with the very case we began our discussion with tonight. And that fight continues to this day. She has very recently talked about, in another setting, about the notion that there are basically 2 rules now in the Supreme Court with respect to many of the executive orders that the president has issued. She said either there's no rule or the president wins. And interestingly, she referred to it as Calvin Ball, from Calvin and Hobbes, the cartoon character. So take a look at that and note that once again, some of these dissents and some of the concurrences and majority opinions are quite virulent and they're quite strong. There is actually Amy Coney Barrett identifying Justice Jackson by name in her opposition to what Justice Jackson is saying in some of these cases. Let's talk about many other cases here. And again, this is going to be frustrating because you're going to say, wait a minute, we're going much too quickly over some very important things. Happy to take some questions at the end of our time together, but I want to get to this shadow docket in particular. Note once again, another religious case. This one, interestingly, 4-4. Why? Because Amy Coney Barrett, one of the 9, recused herself. And in the end, the Supreme Court determined in a case coming out of Oklahoma that the Establishment Clause does in fact permit Oklahoma to prohibit an online charter school, which is religious in nature, teaching the Catholic faith, does in fact prohibit the government can prohibit that charter school from getting benefits of the public schools and being under that particular umbrella, and says basically that there's nothing about the Establishment Clause that prohibits the states from doing that. In fact, just the opposite. 4-4, which means the issue will almost certainly come back, depending upon what Amy Coney Barrett, if she doesn't recuse herself in a future case, we could see this once again. Ghost guns, there you see a picture of that. Ghost guns are these things that, yes, today in America, you can order online the component pieces for an active and an operational firearm. You can put it together in your home, in your basement, and you've got an operational firearm. The question is, in those component pieces, can the government, can ATF, alcohol, tobacco, and firearms, regulate, as it does regular guns, regulate those pieces? And the Supreme Court comes back again 7-2, much to the chagrin of Clarence Thomas, and says that yes, indeed, the ATF, the government, can regulate and can require that there be serial numbers and other identifying information on the component parts. Nothing wrong with that in terms of federal regulations. States can prohibit. This is a very big case. Many people thought, including me, this would be the big case of the term. This is Scarametti, if many of you recall that. States can, in fact, prohibit legislatively, state legislatures can prohibit healthcare being provided to minors undergoing gender transition. Puberty blockers, those kinds of things. A state legislature can make the decision that medical health care providers can prevent doctors and healthcare providers from providing that kind of healthcare. The Chief Justice basically is saying this is a tough question. We've got lots of things, he says, in many different directions that may or may not be the case in terms of how you read the literature. And he says basically it's appropriate for the legislatures of states to resolve this and not the Supreme Court. Going on, this one is, here we got a 9-0 opinion. Everybody agrees on this one. When it comes to assessing whether or not a use of force by a police officer of a weapon, typically involving a shooting and oftentimes the death of someone, how do you determine whether or not that shooting was justified under the law? Do you look very narrowly at just the shooting itself, the seconds around when that happens, or you do look at the totality of the circumstances, again, based upon body cams and other things, the period of time leading up to the shooting and even after the shooting? Not surprising, the Supreme Court says no. You look at everything. You look at the totality of the circumstances when it comes to determining whether or not the shooting was constitutional. Big case under the Affordable Care Act. Yes, indeed, Obamacare was back and before the Supreme Court. We had these task forces, you may recall, from the time that the law was first put in place. They're stocked with people who are experts, they're healthcare providers, and they made determinations about this, about whether or not a particular kind of healthcare provision that is preventive in nature, preventing, not responding to, preventing certain kinds of maladies, things like diabetes and cardiac issues and other things like that, whether this particular task force can make those decisions. There was an attack on their authority to do that, to make those determinations. And by a vote of 6-3, the Supreme Court, again by a majority, a different 6-3 than the one we saw before, said no, nothing wrong with these task forces being in place. Had they gone in the opposite direction, a very big change in the way that the Affordable Care Act would have been interpreted by our government and by insurance companies. The point of what the task forces do is if they identify a preventive healthcare measure or some treatment as being appropriately preventive, insurance companies under Obamacare have got to provide it without additional cost, without any cost going forward. So it's a significant healthcare case, and the ACA remains the law of the land. Let's talk about some other cases here. Mexico sues, believe it or not, manufacturers in the United States of America, including Smith & Wesson, of guns. And they say, you know what? We've got a violence problem in our nation, Mexico, and you caused it. You caused it, they say, by producing all these weapons there in America, and we want to hold you responsible for that. Supreme Court, once again, 9-0, unanimously looks at this as well. Wait a minute. The Congress, a number of years ago, passed a law that said, again, rightly or wrongly, passed a law that said when it comes to suing manufacturers of firearms, they are immune from civil prosecution for that. Again, you may agree or disagree with that, but that's the law. And they say it applies to Mexico. So Mexico, you're out of luck. Smith & Wesson wins, and no liability for the production of guns and the effect that it has on crime in Mexico. Here's one that you probably don't want to run your next campaign on, but the question is whether or not there should be online age verification to determine that the adults who are watching pornography online are all adults. You might think, gee, doesn't that make some sense for people who are in 12, 13, 14, 17 years old, and even much younger? Believe it or not, 6-3, and the 3, including Sonia Sotomayor, is not because of the interest in preventing young people from watching porn on video and online, but rather that she is concerned about the effect on adult access. And there's a long description in her objection to her dissent about the implications under the First Amendment of restricting this age verification for adults. Here's a big one. Federal Communications Commission, $9 billion with a B allocated by the Congress to bring broadband internet to underprivileged and other communities in our nation that do not have access to the internet. $9 billion allocated for the FCC to do this. Again, there's an attack on some of the ways in which FCC members provide monies to support what the FCC does. And the Supreme Court comes back and says, no, this mechanism for funding the FCC is okay. Go ahead and bring the internet into all these communities. It's a big deal, again, for purpose of agency understanding, but also for communities in our nation that, again, perhaps unbelievably, but still do not have internet access. We've got a question about employment discriminations called Title VII that basically ensures that when the terms and conditions of employment, hiring, firing, even the circumstances of employment, you can't discriminate based upon a number of different immutable characteristics, including sex, which has been interpreted to mean sexual orientation and gender identity. You have a straight woman who maintains that she is not given a job and is instead given to a gay man. And she alleges that that's employment discrimination. The question is not whether she is right or wrong. The case has not been tried, but what is the standard of proof that the people who are challenging that need to show? Is it lower? Is it lower, or is it higher? Is it the same as if the minority and majority populations were litigating this case? Supreme Court 9-0 says, you know what? Regardless of what your orientation is, regardless of where you fall in the status of plaintiffs and defendants, everybody has the same standard under Title VII. And then there you see that meme about vaping. Again, an interesting thing about pop culture these days, Food and Drug Administration wants to regulate vaping, not so much to bring it to a close, but to prevent producers and manufacturers of vaping products from promoting them with names that are attractive to young people, that would talk about bubble gum and talks about other things that are flavored in ways that maybe a 12 or 9-year-old would be attracted to. And the Supreme Court says 9-0, yes, FDA, you've got the authority to do just that. That is a wild ride through just about 10 or 12 of the major other cases that are out there. And I'm doing it that way because I wanted to talk with you at great length here tonight about something else that you've heard a lot about. And it is over and beyond the 65 cases that I've identified, over and beyond these. And that is all this commotion about the shadow docket. What is this thing and why is it? And I'm going to advocate for you that it is a matter of concern. And you may have a view about this that makes it appropriate or inappropriate, but let me identify what this is all about. You have seen this a lot, and I'll give you some statistics on it in just a moment or so. These are not cases that are part of the regular process where the Supreme Court decides to take the cases on from all those different jurisdictions and entertains oral argument, gets motions from the parties, gets briefed by the parties. They're very quick decisions. And for the most part, not exclusively, but for the most part, they'd be advanced by, as you know, the present administration, asking the Supreme Court to overturn lower court decisions and do it quickly, and do it even while the lower court litigation is not yet complete. They involve some major issues of statutory construction. You have seen a lot of these, and I'll show you some more of them in just a moment or so. They raise issues about the circumstances under which the Supreme Court should be deciding cases without the benefit of argument doing these major case decisions very quickly, and the very nature of immediacy. What does that all mean? And the other thing that we see as late as yesterday, I'll get to this once again, is we get a one-sentence order. Unlike those other 65 cases, you get a one-sentence, maybe in a good luck situation, maybe a couple of pages, where the Supreme Court will not give you a lot of exposition, but simply say, in the great majority of cases, the president can in fact go ahead and do the things that he is doing. And again, it causes problems, at least from the lower courts, because they don't have descriptions from the Supreme Court about the rationale and the reasons. You'll see how this plays out. And so let me give you some statistics on this. 16 years between the Bush administrations. That man is George Bush. He was the president of the United States of America. The other man, his name is Barack Obama. Between the two of them, they occupied the White House for 16 years. And during that entire period of time, the executive branch sought these kinds of emergency relief applications a whopping 8 times. And only four of those were granted by the court. Compare that to now. During Donald Trump, and again, this is not criticism politically, it is just a part of the statistics. During Donald Trump's first term, the first term he was in office, he seeks relief 40 times. And in the first 7, approaching now 8 months in his present term, the Solicitor General, who is your advocate in front of the Supreme Court, has asked for emergency appeals and emergency review in excess of 20 times. That is a statistical thing that should be noted by all of us, okay? And so let's talk about some of the kinds of things the Supreme Court is doing in this docket that is, again, emergency and making these very quick decisions. I can spend a lot of time talking about all of them, but these are just a sampling of about 20 of those altogether. The Supreme Court permitted the president on an executive order to terminate the humanitarian protections for many, many people, migrants, asylum seekers, 800,000 people, 2 different programs, 800,000 people. Basically, the president, by executive order, terminating their status here. The Supreme Court saying, yes, indeed, you can do that. There's a big one for the military, transgender military members. The president issued an order again on his first day of office saying, you can no longer be a part of our armed services. Challenged in court and reversed in court. But the Department of Justice goes to the Supreme Court and says, we're challenging that. We're asking the Supreme Court to overturn what the lower courts have done. And the Supreme Court, again, in a one-line order says, yes, indeed, you can get rid of the transgender members of our military. A lot of these cases involving members, as you've seen, on various agency boards, governors and boards of directors of the National Labor Relations Board. It has a lot to do with unions. The Merit Systems Protection Board, the president is firing, as you know, again, by executive order, simply firing people in the agencies that are out there. Can he do that? Well, lower courts have said, as they're litigating this, for the most part, no. The Supreme Court has said, well, nope, we're going to let you go ahead. Even while the underlying litigation is going on, you can still terminate those people from some of the major agencies. And here, of course, is the big one. And we could spend 2 hours talking about this one, many different ways, including the situation involving Kilmar Abrego Garcia, which you know well. Huge numbers of decisions being decided by the Supreme Court, 1 or 2 of them on the merits, but many of them permitting deportations by Homeland Security, by the Justice Department, without a full exposition before the Supreme Court. Again, lower courts, including people like Paula Zinnes from Maryland, District Court Judge, James Boasberg from the District of Columbia, saying, wait a minute, you've got to give them due process. The Supreme Court coming in and saying in many ways, we'll let that litigation go on, but in the meantime, you can go ahead with all kinds of deportations of people who are the subject of immigration issues. Let me do a few more of these and then we'll begin to conclude. I'm going to be very quick on this, but I want to give you some sense about the timing on all this from mid-June to just yesterday. A major case, again, a shadow docket. Lots of controversy about this, whether or not the Musk team, I'm not going to refer to it as DOGE because it's not a department, it's the Musk team. Can they have access to all the Social Security information? Go in and get access to that. Elena Kagan and others say, you must be kidding me. And the answer by the Supreme Court is yes. And you should know, whether you approve or disapprove of what the Supreme Court has said, the Musk team has had access to all the Social Security information based upon this application of the Department of Justice. That was in June. In early July, the Supreme Court addresses this major executive order issued by the president saying, you know what? I want to get rid of lots of people and lots of agencies. I want to reduce the size of these agencies. An executive order for shuttering various agencies, including education, but others. The Supreme Court once again says, frankly, this time a 9-1 majority, you can go ahead and do just that. Ketanji Brown Jackson, you see the language there. She is very upset. She says, by doing this, you are upsetting very great numbers of constituencies out there. Nonetheless, coming out of California, the Supreme Court says you may go ahead and do that. That's early July. How about mid-July? Remember this one? 6-3 majority says, yes, indeed, the president can fire about 1,000 people and aside the Department of Education and can do other things to bring the agency basically to closure. You once again get the same kind of thing. Sonia Sotomayor, Kagan, and Jackson saying, no, unleashing huge consequences here. You see the language there, and this is problematic. The president permitted to go ahead based upon the shadow docket application here. Here's another one in late July. This has to do with the Consumer Product Safety Commission. These are the toys that all of our children do, and many other things, the appliances in your kitchens. The question is whether or not the president can fire members of this commission who make these determinations. And this, again, without a lot of briefing. And while the litigation about this is going on, the Supreme Court says, yes, indeed, 6-3 vote, you can get rid of those Consumer Product Safety Commission members. And here's the one from just yesterday, in case you think that's not enough. This is a judge named Mame Frimpong. She's a district court judge. Remember, I pointed to the Central District of California a while ago. She issued an order. You know what's going on in Los Angeles right now. She issues an order that says when the military is here, and even when domestic law enforcement is here, before you can detain somebody, before you can arrest them in California, what you've got to do is you've got to make certain, consistent with what has been the traditional practice, that you have a reasonable suspicion that they've done something that's illegal. That's basically been a standard for years, decades, maybe much beyond that in America. And you can't do it based upon, you see those things there, race, because they're speaking a language that's other than English, because they're working at a particular labor site that you might find is problematic, or that even their presence in a particular community. Can't do that. That's profiling, and it's not reasonable suspicion. Yesterday, the United States Supreme Court, 6-3, again in a one-sentence order, overturns Judge Frimpong and says, no, the military and other forces there in Los Angeles can in fact do this. All they need to do is bring together a number of those different, otherwise unsupported considerations. And if you bring enough of them together, then you do have reasonable suspicion. And basically, Justice Kavanaugh, who again, he does addend his own concurrence. He issues a very long concurrence, and he basically says, you put all these things together, you do have reasonable suspicion. And by the way, in California, in this particular area, you've got huge numbers of populations that are in fact illegally here. So if you round up a lot of people, like round up 100 people, it's about 10%. You probably will have 10 of those people who are indeed subject to deportation. It is a major decision. It is causing a lot of very dramatic concern around the country about the way in which law enforcement works in America. The shadow docket just yesterday. And finally, in this area, this goes back a little bit. There's some good news here, which I promised Carrie I'd spend some time on. This comes out of the Eighth Circuit, has to do with the Voting Rights Act. The Eighth Circuit basically issues an opinion not too long ago and says that the only entity that can prosecute voting rights cases is the U.S. Department of Justice. That has never been the case since the mid-1960s. And in fact, most voting rights cases are prosecuted by private entities and individuals. Eighth Circuit says, nope, we're shutting down all of those private pieces of litigation. And it has to do with an effect upon some tribes there in North Dakota and in other places. The Supreme Court takes on an emergency application, not from the government, but from the tribes, and says no. Eighth Circuit, stand down. Do not enforce this. Again, a situation where you've got an emergency application, the Supreme Court intervenes to prevent the Eighth Circuit, at least for now, from going ahead with this major change in voting rights. The reality is that they may revisit that at some point down the road, which brings me nearly to an end here, which is what's going on next term. Lots of things. There are 32 cases already. Here are a couple of them. Remember this word, Calais. Calais. This was the Louisiana case. Supreme Court was on the docket this past term. Interestingly, they failed to decide it, and they kicked it into the new term. This is one involving line drawing in Louisiana, some congressional districts, creating 2 majority Black districts there. Allegations that the Voting Rights Act, by virtue of compelling that to happen, is in violation of the Constitution that provides for equal protection. And it may well be that Calais is in a group of cases that the Supreme Court will take up this term. They will take it up. They've already put it on their docket, in which they may address the very vitality of the Voting Rights Act itself. There were some other cases in the past in which they've chipped away dramatically. One of them called Brnovich, and the other Shelby County, which you probably recall, a major civil rights case. You also have a number of different cases, 3 actually, involving orientation and gender orientation, sexual orientation, and gender identity. This one, among others, is again the issue of women's sports. And can transgender athletes participate in girls and women's sports? It's on the Supreme Court's docket. There's a case involving all kinds of things. There's a backdoor case involving abortion. There's a backdoor case involving the Religious Liberty Protection Act. There are cases involving campaign finance as well. All kinds of things on the docket. There's a death penalty case as well, also before the Supreme Court. Many things we're not talking about tonight. It's going to be an interesting docket. Let me again pull all of this together and provide you with some general views about this and some trends. You may disagree with this. That's the beauty of our nation, right? First Amendment stuff. A dramatic increase in the use of these emergency applications to decide major decisions as late as yesterday and during the past 7 months, and even before that, even during the Biden administration, there was some of this going on. Increased rancor. I haven't spent a lot of time talking about it, but rancor between the justices. They've always sparred. That has always been a part of their history. It is to a much higher level than it has been. It's not name calling yet, but it's closing in on that. Also, a significant reallocation, once again, of the power of the presidency. A year ago, when we got together, I told you all about United States versus Trump, which is not only the case that provides that a president does in fact have immunity for certain crimes committed in office. This year, this CASA case basically is saying that when the president does these things, issues these executive orders approved on the emergency docket, that you can't get a nationwide injunction to prevent them. You've got to go into every single district around the country to get those stopped if you choose to do so. It is basically viewed also as a strong encouragement of the power of the presidency. And then once again, we've got an awful lot of focus. This has been true of the past term and this term again on religion. Free exercise, Establishment Clause, lots of issues again coming up about education and the environment and civil human rights, including, once again, LGBTQIA issues. Just a notation that we do have elections coming up in a year. It's beyond, of course, even though the president has issued some executive orders here, remind you that the legislature on many of these issues was designed initially, Article 1 of the Constitution, to decide many of these issues. You want to encourage that, you need to vote in 420 days from tonight and today. 480 days, the 120th Congress goes into session. The United States House of Representatives has a lot of authority, including, arguably, I think clearly, to do things called tariffs. That's going to come up before the Supreme Court. The United States Senate does a lot of things as well, including deciding on federal judges and U.S. attorneys and U.S. marshals and an awful lot of people in our federal system. And so we've come to that time finally for questions, comments, observations as we begin to wrap up this very, very rapid movement through the Supreme Court's term just this past year or so.
Jim, as always, thank you for a lightning speed civics lesson. It is jam-packed full of information that is important for us to know. First question I've got for you is about the shadow docket. Are the emergency decisions typically permanent, or are they just saying let these actions go on? That is, are they typically the last word or not?
Terrific question. It is understood that it's the second portion, Carrie, what you just said. We'll let the president do these things, but the underlying litigation will continue to let that go forward. And it may well be that those decisions from the appeals court will come to us as a part of our merits document. And we may well decide that we were wrong, if you will, to let things go ahead, or we could go in the opposite direction, but they're not intended to be permanent. The opposition to that is, well, but if in fact you're making a determination, the president can terminate people from a position, can rescind funds for organizations and for other entities, can stop overseas funding to do all kinds of things. If you come back in 2.5 years and say the underlying decisions show that he was wrong about that, it's going to be pretty hard to turn that back, right? And that's not a political statement. That's just about a reality about litigation. And that's the reason why an awful lot of people say that these decisions, even though they're not meant to be permanent, effectively have the impact of doing something that cannot be reversed.
Thank you. Ahmed had a sharp comment here, which about yesterday's decision. If I have brown skin, a foreign sounding name, speak a little funny in the opinion of an ICE agent, and work in a church that has a sanctuary policy, am I in trouble? Should I be worried?
And I will tell you what my opinion is on this. I think this decision yesterday, again, shadow docket, not only changes the way that law enforcement across the country, you've got the mayor of Los Angeles saying, people, this is not just here. This is in Milwaukee. This is in Boston. This is in Wilkes-Barre, Pennsylvania. This is all around the country. The reality is that we change the way that law enforcement works. And yes, indeed, if you read Justice Kavanaugh's concurrence, he basically says, Carrie and Ahmed, exactly what you said. If you've got maybe 2 or 3 of these indicia, that is enough, and I can detain and I can arrest, because statistically, when I do that, I'll be right, and I will find people who are engaged in violations of the law. That is not what I have taught to law enforcement. That's not how I've worked in the federal system for many, many years, and it is a dramatic change. And so I think it is a reason for great concern among populations, not just in Los Angeles, but across the country, who may fall in some of those categories of immutable characteristics. I think the concern is legitimate.
Mhm. I I think back to some of my seminary professors who would have comments about one's theological anthropology
Yes.
related to those statements.
Mhm.
So, um, I had another question. A lot of my colleagues have been quite taken by these religious freedom
Yes.
decisions around the schools.
Mhm. Yes.
And they've been musing about what it means for their religious freedom as folks
Mhm.
who are not Christian
Right.
nationalists. And what it would be like if they were to pull their children from the schools from the public schools when,
Mhm.
say, Ten Commandments were displayed in the
Right.
schools and things like that. You have any musings on that?
Yes, again, would love to go on for an hour and a half, and plainly I could do just that. This is a huge issue only because those members, those 9 people, at least 5 of them, if you've got a religious exercise case and even a challenge to establishment, and you're asking for review by the Supreme Court almost always takes it. They are, especially the Chief Justice, they are fascinated and focused upon religious cases. And you know the history of this, of course. Carrie, your reference to whether it's the Bible or the Ten Commandments. We did this way back in the 1950s and 60s. Said, you know what? You cannot in public schools. Once again, private schools, different situation. We're talking about public schools. You cannot stand in front of any class and say, open your Bibles to the book of Isaiah, and we're going to read. Right? You can't. That is violating the establishment of that is establishing a religion inside public schools. It also works when it comes to various other things that, again, traditionally we've thought that there is a clear line between church and state. This is that. In recent years, without going into great detail, there have been a whole series of cases in which, again, at the pen, principally of the Chief Justice has said that the issue is not whether or not the government and schools are entangled with religion, and so we're getting rid of the entanglement test. Instead, the standard is whether or not you are somehow discriminating against religion. And what that means is if you've got a religious entity or a school that comes forward and says, I want to make benefit of some public funds, for example, whether it's for construction or some scholarships, the Supreme Court has said, again, many other circumstances, you cannot prohibit public funds from being used for those purposes, deny them access, because to do so would be to discriminate against religion. He's changed the standard, and what it means is religion, again, with great respect, and do not mean this in any sort of non-deferential way, religion wins these days, both on establishment issues and on free exercise issues. The Maryland case is one example. We've got others coming up in this time. And just know that in that area, with a couple of exceptions around the edges, religion, you will make an allegation, a charge that my religious faith says to me that this is what has to happen here. And that is given not only great deference, but and it should be given deference, right? But it overcomes the longstanding hundreds-year prohibition that we've had on not establishing religion inside public schools and public entities too. And so it's a trend that I think is very, very marked in the past term. My guess is it will see it again in the coming term. When we get together next year, you invite me back again, I suspect we'll talk a lot about that very issue, Carrie.
Without keeping us here for a second hour of class, which would be very easy for us to do, I think. Do we have any evidence that interest by the court in upholding that free exercise holds for folks other than Christians?
That is the all told question, right? Let me use again, at the risk of extending this a little bit. Remember the Bremerton case? This was the fellow who was the football coach in Washington, right? And he is having prayers among the football team, and he's doing it, it turns out, on a 50-yard line of the football field Friday night. Everybody is gathered around, plainly a public setting, right? And Justice Gorsuch comes back and says, well, this was a private thing. Nobody was obliged to do it, and permits and overturns basically lower court decisions that say, no, you can't have prayer, which is Christian prayer, to your point, and in a public school. And again, Sonia Sotomayor responds to that. She says, this is not a private small thing. You are plainly violating our longstanding tradition. The larger answer that I would give to you, Carrie, is in virtually all of these cases, I can't think of a one in which there is a Muslim or a Jewish or a Sikh or a Hindu or a Buddhist or a Jain petitioner who is asking for the same kind of thing that a Christian petitioner or challenger is asking for. An awful lot of people write in opinion pieces, which you can agree with or disagree with, that if indeed these were not Christian religious cases, but they were from other members of the wonderful interfaith community that this group celebrates, would this Supreme Court and would John Roberts himself embrace this erasing of these lines with the speed and the clarity with which he's doing it?
What are your views on the public disparaging of judges and in some case threats to them?
It is horrific. And I will tell you again, at the risk of sounding very political here, I don't mean to do it. It starts at the top, right? When you have, as late as this past week, when my president calls and one of the judges in the lower court did a catalog of all the words. They're not, rogue is frankly fairly docile, right? when they're crazy, when they're untethered, when the Attorney General says they've got no power whatsoever. And again, they won't use the words in particular. When our highest rule of law officials, the Attorney General and others plainly across the country, do the name calling and say that they're, again, typically they're liberal, out of control judges, that not only undermines the validity of the process, which again can be pursued by an appeal and all those kinds of things, but also says to Americans generally that, you know what? Our court system, don't trust it. And that great concern about that is that's when the entire rule of law system begins to break down, right? Because when the day comes, and maybe, I hate to say it, maybe these 9 folks you see there in that sketch, if they issue an order, and they have done a lot of things, and we abide by it, but if sometime this attack on the judiciary, including the Supreme Court justices, appeals court justices, Judge Boasberg has again gotten threats, Judge Zinnes, who's presiding over some of these other cases out there, if those things are permitted to happen, there may well come a time when judges will issue orders. And as the president has said, how are you going to enforce them? Go ahead, you and what army? That is a great threat to the future of the republic. Even if you don't like what these courts are doing, you can't have both of those things. And the threats, plainly of physical injury and harm, we've seen that, are completely condemnable. Cannot have that in a genuine republic and a democracy that relies on rule of law. Even the name calling is undermining the system, and I condemn it in the strongest language possible.
Thank you. I'm going to give you the last question, which is actually a pivot to our call to action. You have invited us to mark our calendars to vote
Yes.
in the next major election cycle, never mind minor or not so minor opportunities that may come up in between. But we have had someone ask, aside from voting, what might we do to
Right.
stop this frightening undermining of rights and dignity?
Right.
So what would you invite?
Yes, I would invite, again, important to underscore this, the civil and nonviolent protests. I do think that they have an impact because they send to the country, whether it's 12 people on the side of a street or 1,200 gathered in some park, they do send a message that there is concern out there, and it's not a fringe concern. It's a concern about the future. I think that's important. And so to the extent that that is something that you can do, I encourage that. Here's the other one that I encourage all the time. And I'm going to do something that's very odd here. I've got a show and tell kind of item here, and that is a roll of stamps. You might say, gee, Jim, how much postage are you buying here? It turns out you can buy this for $72. But here's the non-tongue-in-cheek response. You know what I think can be also effective? The calls, yes, to members of Congress there. The postcards can do that. But if you've got, again, go back, and I can even give you a list of some of the judges out there. I can give you their addresses as well. Both the judges who you may have a difference of opinion with, the judges who are entering these orders, the Judge Frimpongs of the world, who you want to support, write a letter to them. Pull out a piece of paper, take out a pen, date it, and say, Dear Judge Frimpong, I know that the Supreme Court recently told you that you were wrong. I want to tell you that I support the notion that people should not be arrested on the streets of America based upon immutable characteristics, and I want you to know that. Sincerely, Ahmed Qureshi, right? And I say that because when you think, and judges will not be able to respond to you, members of Congress will, but if you even tell those judges who are, from my perspective, doing the right thing and upholding the law, and yes, indeed, saying the 14th Amendment does have meaning, and it does mean you've got citizenship, if you send them those letters, they get open. I think about, if you go to your post box tonight, or you've already done it, and you get all those papers, as we always do, the various advertisements and the letter, the bills and all those kinds of things, and you come across a letter that has a stamp on it, and it's handwritten, and it's written to you, what is the first thing you do? It probably doesn't even make it inside your house. You open that note, don't you? Because somebody took the time and the effort to write, and I believe that that too can have an impact You'll never know. We always see those Hallmark stories and those Hallmark productions about somebody reading a letter from a 12-year-old or even a 72-year-old and it changing things. I would recommend you do that. You may not get an instant gratification, but you've been a part of the system and you advocate for that. And again, as you just said, Carrie, voting 420 days from now, got to do that. And advocating, frankly, for those candidates who represent in that legislature, Article 1 of the Constitution. They're the ones who should be deciding all these things, not the president by executive order, not the Congress, or not the Supreme Court. By its necessary resolution of these cases, the legislature should be wrestling with and deciding these big issue cases. Tell them that.
Thank you. You have your call to action, friends. You have learned an awful lot tonight. Hopefully you have been inspired and left with a bit of hope. You have contact information before you. You have an opportunity to write it down. I invite you to mark your calendars for next month, the second Tuesday of October. We have not received a confirmation from our speaker yet, but I can tell you we are working on a speaker who can give you information about what you can do as an ally when you encounter ICE. So keep in mind, this is something that is for all of us, not just for those who may have direct immigration concerns of their own. It is something all of us should know and how we might be good allies. So with all of that in mind, Reverend Briscoe, I believe you are here. I am going to invite you to unmute and offer our closing reflection.
Thank you. All heads bowed. Most gracious and benevolent Heavenly Father, we come to you as your handmaid servants tonight, asking you to empower us through your Holy Spirit that we will not faint, we will not be thwarted, that with your power and your unction, we will be able to stand against these evil wiles that's permeating through our country, from the leadership, through the courts, even from our Constitution, that your people, as your people, can stand and prevail against the evil that is projected upon us from high places. That all citizens, all human beings, all inhabitants of your planet Earth will be able to realize that we are nothing without each other, and that we are all included in your eternal and forever lasting hope. And we are all included in your plan. So let us behave likewise. Let us look to our neighbor, to the foreigner, to the orphan, to the widow, with our benevolence and with the mercy that you bestowed upon us. And let us bestow it upon them, and let us bestow it upon each other, so that this nation, this world, will finally see what it is to live in love and respect. All of these things we ask of you and count them all done. Amen.
Amen. Thank you, Reverend Briscoe. Thank you, Jim. As always, it is a pleasure to hear from you and learn from you. Thank you, colleagues and friends, and keep courage. Good night.
Good night, everybody. Thank you so very much.
Peace.